Happy Halloween, everybody, and welcome to Block and Order, the show that explores the legal issues facing the world of Web3. I'm Kyle Lawrence, and with me, as always, my partner in crime, Freddy Krueger has nightmares about him, Moish Peltz, everybody.
Hello, Kyle, and trick or treat, everyone.
Yeah. What are you dressing up as for Halloween, Moish?
A crypto bro.
A crypto bro. Nice.
No, I got one of those exclusive Costco sweaters that has the Costco warehouse, so yes. I'm going to be a Costco shopper.
That's good. That's good. The Kirkland brand. I like it. You know, I'm a disgruntled middle-aged man.
No, but for Halloween, Kyle.
Oh, yeah. I forgot it was Halloween. I didn't get that memo. All right. Let's take us away with the order.
Get to the top of the order, then. So today we're starting off with Yuga Labs, which won a significant victory at its trial on damages that occurred recently. So the judge ordered, basically this was a trial that happened after liability had already been decided, that there had been trademark infringement and there had been bad faith intent to infringe on the domain names, and that Ryder Ripps and Polly had not had fair use. So the court ordered a disgorgement of profits in the amount of $1.375 million in favor of Yuga Labs, as well as statutory damages, about $200,000 on the cyber squatting claims under the ACPA. It also notably granted Yuga injunctive relief, and it required that Ryder Ripps and Polly stop selling and marketing its NFTs. It's closed down the ape market that it created and transferred control of the NFT smart contract to Yuga Labs. And then perhaps from a monetary perspective might be the highest dollar amount. We'll see what this number ends up being.
Right.
An award of attorney's fees, which was discretionary, but the court in its discretion found was appropriate in this particular instance. So, Kyle, what do you think about the notability of this case in this industry?
Sure. Well, it's certainly high profile. Everybody knows who Yuga Labs is, and everybody knew that this case was pending. What I find curious, and I'm not an intellectual property attorney like some smarter folks on this video are, but where is that line drawn between what is satire, what is parody? Because Saturday Night Live can parody a political debate all at once. I mean, those are public figures. It can parody a Coca-Cola commercial. Where's that line drawn between what's fair use and what's not? As a layperson, how would that work?
Yeah, so of course that's what the defendants were kind of screaming from the rooftops. This is just a parody. We're making an artistic statement about all the negative things we see about the Bored Ape Yacht Club, which I just happen to be wearing a sweatshirt of. And the court didn't buy it, right? That was part of what the submissions were to the court on the summary judgment motion was, here's the facts, and the court had to make a decision as to whether, which argument it believed. But that's going to be, you're seeing more and more, and not just in the NFT context, not just in the crypto context, but in more generally in trademark and copyright law, there's a huge element of, right, how much of this is for commercial activity, how much of this is free speech. Increasingly, you're seeing intersection of activities that are both commercial and perhaps speech adjacent. So there's this kind of mixed commercial activity, mixed speech activity, and there's tougher calls for the courts to have to make about what is on which side of the line and
right,
what kinds of activities are permitted. In this particular case, the court just didn't buy it, right? It said, it compared it to, Andy Warhol is one of the great examples. And, and the argument here is, well, Andy Warhol wasn't selling soup cans, right?
Right.
Which I think he ended up actually selling like soup cans. I believe
he did.
Like as part of it. But it was like, the primary purpose was art, not soup cans.
Right.
And the idea here is the primary purpose was selling NFTs, but then it kind of becomes circular, because is an NFT really art, or is it really a physical, some sort of virtual object? So anyways, court didn't buy it.
A lot of stuff going on there. I mean, you're talking about what is art, what is free speech. I mean, as just being a citizen of the United States, free speech is one of those things that we all know it exists, but few people actually know what it means and what its limits are. And when you start introducing a speech component to this kind of analysis, I think that's really interesting, and people are going to be, I don't know, some people will be upset with this. I mean, people are upset with anything, these days. But I think people might be upset if there's a view that this was somehow curtailing Ryder Ripps's free speech rights. I'm just curious to see the fallout from this. Interesting to see where this one goes.
Yeah, he also had it's called anti-SLAPP, right? Is the kind of law that they filed a motion on anti-SLAPP grounds, which was denied. The appeal on that to the Ninth Circuit was also the appeal was affirmed, so their motion being denied was appealed to the Ninth Circuit already. So that so far all their free speech arguments have been rejected at this point.
Where does Ryder Ripps go?
Moving on to our next topic.
Oh, sorry.
Yeah, no, we could probably talk on that one for
time's up. Yeah,
I think we're gonna have to do a special presentation just on commercial speech versus free speech, and the intersection. All right, for our next topic. A little bit of a third rail issue, but the Wall Street Journal reported this past week that Hamas, the terrorist group, had raised as much as $93 million in cryptocurrency, and that money was being used to back the current war in the Middle East. However, subsequently, the blockchain analytics firm Chainalysis, and then later Elliptic, refuted that idea, saying that the funding was likely in the range of a few $1,000s, and that the few $1,000s they could find actually had made its way to crypto exchanges that had actually frozen it. And in fact, USDT Tether had frozen some of those funds as well. So despite all of that, only belatedly did the Wall Street Journal make a acknowledgement of some of these concerns. That didn't stop in the meantime. Prominent members of Congress, including Senator Elizabeth Warren and Senator Sherrod Brown, from continuing to push for a much broader crypto crackdown. So, Kyle, I mean, what does this get to in terms of, is this bad faith by government? Is this just misunderstanding the technology? Is this just people grasping at straws to paint a narrative that they're already painting? What can we take away from this?
Well, I think there's a lot of things going on here that are, obviously unfortunate. Look, this is a terrible situation. Nobody is disputing that. There's obviously a lot to unpack in here, and what's unfortunate is that you have a reputable news periodical that put out this report, and by the time they issued the retraction, the damage is effectively already done. You have prominent members of the Senate, just continuing to bash crypto, whether that's wanting to fit their narrative or they actually believe that, Hamas used this technology to fund its own, terrorist activities. It's really difficult to kind of pinpoint any one thing here, but the fact that the Wall Street Journal did this, I think, is really problematic. And I think Senator Warren and Senator Brown coming forward and just continuing their crusade against crypto, it's not solving any of the problems, and it's not really addressing the greater issue that's in play here.
Yeah, I think it's emblematic of a lot of just the misinformation or just lack of understanding that you're seeing institutions that interact with crypto. This is just kind of paints a broad picture of people seeing reporting that they don't quite understand or maybe is misleading. Some of the criticism from Chainalysis was that the initial report that these numbers were based on may have been inaccurate, right? So it's people seeing numbers, which $93 million, holy moly, that's a lot of money. Like,
right.
Yeah, of course we got to make sure that people aren't using crypto to launder $100 million of terrorist financing. But, I think when you get down to the reality, it turns out that that's really not, at least what it appears to be happening.
Yeah, I agree. So, Moish, tell us about the LBRY case.
Thanks, Kyle. So LBRY shut down this past week after losing its district court case on the question of whether the sale of LBRY tokens was an unregistered securities offering. LBRY initially announced it was going to appeal and filed a notice of appeal, but then reversed course and in a public statement said that it just doesn't have the funds to continue as a business and to continue the appeal. So it's shutting down, putting its assets in receivership and basically paying out its investors with whatever assets it has left. And additionally, Commissioner Hester Pierce of the SEC filed a dissenting statement excoriating the SEC on this particular issue now that the case has resolved. So, Kyle, as a securities lawyer, how do you view the SEC's actions here?
Well, surprisingly, I agree with Commissioner Peirce with her dissent, and this is just bad faith. This is just the SEC trying to, stake its claim as the arbiter of what is and what is not appropriate in this industry. And I think the whole thing stinks to high heaven. And what really grinds my gears is that LBRY was seen as the paragon of the way to do this correctly. They had a fully developed platform. They did a traditional correct raise. The tokens were consumptive. They had an actual use for them on the release date. They did everything they were supposed to do, and yet the SEC still just completely dragged them through the mud. And what I think, one thing that's pretty interesting is that originally the SEC was seeking $44 million in damages, and then they pared that down to $111,614. I wonder where they got that number. Maybe that was the final pennies that they had. So as somebody, from your seat, Moish, SEC obviously went scorched earth here. Do you think that they did this to protect retail purchasers, as is their mission, or did they do this to try to set a precedent for themselves moving forward to go after similar ventures?
This is an example of, a good regulator on the street just trying to help customers. No, it's like ridiculous. You can't even say the words, right?
You were close. Yeah.
I couldn't even make it through.
Yeah.
I tried. Look, it's ridiculous. This is a company, as you said, that did a separate offering with accredited investors, et cetera, as a real fundraise, and then had the token as a separate component from all of that. I don't know what the SEC wants them to do.
Right.
And if there is something they want them to do besides what they did, they should tell the market that, right? They should tell companies, here's how to do it. Here's a roadmap. Here's an example of what you can do. And they're just not doing that, right? This is a company that, I'm not going to beat a dead horse, right? So, I mean, what'd you think of the dissent then? I mean,
I think the dissent had a really interesting quote from Commissioner Peirce. I'm just going to go ahead and read it because I can't do it justice. There is no path for a company like LBRY to come in and register its functional token offering. Even if a company did manage to register its token offering, it would not be a particularly useful effort. Compliance with the securities laws is important because we want to ensure that people buying securities receive accurate and reliable information so they can assess the risks and rewards of an investment. LBRY did exactly those things, and still the SEC just wiped them off the map, off the board.
Yeah, I mean, it goes to show that there's no real pathway to do this in a regulatory compliant way, and you're yeah, like, all right, well, there we go.
Okay. A case that's not getting a lot of attention in the larger publications, and I'm curious as to why. It's called Jarkesy versus SEC. This is not a crypto case. This is not a Web3 matter, but I think it's going to be very important.
You answered your own question, Kyle.
But it's not getting a lot of attention elsewhere, and I think this is very important. Maybe I'm just being a nerdy SEC securities lawyer, but the long and short of it is that Jarkesy was this individual who was running two separate hedge funds, and the SEC filed an enforcement action against him, saying that he didn't file the appropriate registration statements, did not comply with the federal securities laws. I'm going to yada yada over that. That's almost not important. But what's in play here is that Jarkesy then sued in federal court the SEC, claiming that they violated his Seventh Amendment rights to a fair jury trial, because what the SEC did was they just filed an enforcement action. So for people who aren't familiar, the SEC can either file an enforcement action where they basically adjudicate the matter themselves using what are called administrative law judges, or ALJs, or they sue you in federal court. We've seen them go both ways. When they sue you in federal court, you go before a judge, you have a right to a jury trial, all those things. In enforcement action, you don't have that. The SEC files its own, they conduct its investigation, they file their own action, and then the ALJs come in and decide your fate. Now, they're supposed to be independent, but they're really not. Now, what's happening now is on November 29th, so in just a few weeks, the Supreme Court is actually going to hear this case, and they're going to determine whether or not the SEC can use its own administrative law judges to determine these actions. So all these cases that we keep talking about, going after the NFT projects, going after these crypto companies, if the SEC can't use their administrative law judges to administer these actions and to adjudicate them, it's going to be really interesting to see if this happens a real kneecapping effect. So, gun to your head, Moish, how's the Supreme Court going to decide this?
Yeah, reading the Supreme Court tea leaves is something of a passion of mine.
All unread. There you go.
I know, right? Yes. Well, look, I think you're seeing probably two countervailing issues here. One is which Congress is somewhat dysfunctional and having a difficult time passing legislation to cover deep issues like this, right? Like how the SEC should be handling enforcement actions in new areas such as crypto. Even though this isn't a crypto case, like that's just a broader question, right? And then you're seeing on the other side the Supreme Court being, I think, with the current membership of the court, much more hostile to administrative agencies and potentially them reaching beyond the express limits of what they're trying to do in the statutory purpose of the legislation and their enforcement powers. With that said, I don't know, as far as I understand it, like having an administrative law judge to oversee enforcement actions is like squarely within like what ALJs do in the SEC. Like, I don't know. Like, so it seems like maybe that's okay, but I'm curious what you think.
I think this particular iteration of the Supreme Court is hostile towards government agencies and them using their power. We've seen what they did to the EPA. We've seen what they've done. Actually, not to the FDA. That's for another topic for another day. But I think they're going to come down and they're going to say, you know what, SEC, you can't do this anymore, and see if the SEC can find a workaround. It's curious. I think this is a very interesting case that's not getting a lot of attention. So maybe it's just
and that's really interesting because I do a lot of trademark work, and the USPTO works very similarly, where there's kind of administrative judges that empower the whole process, right? And so you start talking about the broader effects of changes in law like this and the way administrative agencies work. It's very interesting. So our next topic is, once again, our friend Sam Bankman-Fried, who I was privileged enough last week to go down to 500 Pearl Street, which is the courthouse where the trial is being held. And I got to, from inside the courtroom itself, not from one of the overflow rooms, got to witness a day of trial with some of the jury there, and then some without the jury present, with Sam Bankman-Fried actually in his preview testimony outside of the view of the jury. And what an incredible experience to see. You were just talking about the way the judicial process works in administrative court, and this is a real district court hearing with real attorneys on both sides, like going at it.
How long did it take you to get in?
So if you talk to reporters, they tell you they start lining up at like 3 or 4 a.m. to get into the courthouse. Now, they're not supposed to say that. There's like a reporter's code, but like they're clearly lining up really early in the morning. So whatever. The trial's almost over. And I'm admitted to the Southern District of New York, so I have an attorney pass that lets me kind of skip the line. So sorry, reporters, but I was able to kind of just waltz in at the last minute.
Do you think, given some of the weight and the damning nature of the testimony that had been heard prior to him taking the stand, particularly Carolyn Ellison, which we talked about last episode, do you think he helped himself? Do you think he hurt himself? I'm curious as to see what your thoughts were in real time as this was happening.
Yeah, I thought under the direct testimonies, that's when his own attorney is asking him questions and he's answering kind of like scripted, prepared remarks. He was really good. I thought he was confident and well prepared and had thoughtful answers that attempted to shift blame and say, I was just an ineffective manager versus someone committing fraud, right? I mean, that's the story they want to tell.
Right.
So I thought that was quite effective. And then, on cross-examination, that started just kind of imploding and a lot of, I don't recalls and I'm not sure and I don't remembers, which, it sounds like is playing out yesterday and today in front of the jury. And I think there's only so much of that the jury's going to be able to digest before they're just like, this guy just isn't being candid on the stand here. So, you know, I think it played out well. I think, you know, from what your question was, like, how much of what happened in the past few weeks is going to really, like, that's probably what's going to matter, is like 20 people coming up and saying, I agree, we committed fraud, I'm sorry, and it was Sam's fault, versus Sam saying, no, it wasn't me. But that's obviously what the jury has to decide, and it's going to have to make a credibility assessment there.
Right. Really interesting stuff. I'm jealous that you had the opportunity to go see him. Just as a practitioner, that's something that we should all be lining up to do. So I'm jealous.
I mean, look, you can still go down. There's another day or two.
Yeah.
But look, it was incredible to watch both the prosecution, Danielle Sassoon, who's the AUSA, and the defense counsel, as well as the judge, Judge Kaplan, really amazing figure in the legal community, and seeing him oversee the trial was really an amazing experience. On October 25th, the cryptocurrency exchange Kraken informed its customers that it would comply with the limited scope John Doe summons in favor of the IRS. Kraken agreed to provide customer data to the IRS on customers with at least $20,000 in crypto from 2016 to 2020. This is similar to the IRS's prior use of a John Doe summons from Coinbase back in 2018, and indicates that the IRS is looking to pursue Kraken customers who did not comply with their tax compliance obligations at some point forward. So, Kyle, you know, what does this speak as to the larger goals here of the IRS trying to crack down on crypto tax payments?
From the files of I'm tired of being right all the time, I remember saying throughout the first half of this year, you know, everyone in 2021 made all these gains and they never declared any of them. And then in 2022, when the bottom fell out, everybody had losses, and all of a sudden everybody's reporting their losses. What are the odds? But I think this is part and parcel of what we talked about earlier. You have a lot of these government agencies that are trying to get their arms around what this industry is doing, and you know, they can put on the good face and say that they're trying to limit bad actors in the space, which is part of what this is doing. I'm wondering if it's part of the broader effort. You know, we're talking about Hamas and people funding terrorism. I don't think it's the same thing as that, but it can be part of the same engine and the same thing they're trying to accomplish. This is a no-brainer. I mean, there's no surprise that this is happening given what everybody did and did not report over the last 2 years.
Yeah, I you know, the IRS is trying to raise more revenue. I think they need to, given all the spending that's happening in Washington, and very clearly they perceive crypto as an area where there's a lot of non-compliance and a lot of people who just aren't paying their fair share given the gains they've had. Now, I'm sure for a lot of people that had gains over the past few years, those gains don't feel great and may have been illusory if they then went on to lose all their crypto. Or all the crypto went down in value. But the IRS is certainly going to take the position that once you have that gain, you know, a subsequent loss isn't going to obviate your requirement to accurately report and pay whatever your tax obligation is.
That's an interesting argument. I wonder how many people are going to try to get creative. You know what? I'm going to ask our tax group how many of those phone calls they're going to get. Well, I had all these gains a couple years ago, but I just got killed last year, so we're even, right? I wonder if that's a sellable position to take with the IRS. If anybody wants to you know, be a guinea pig and volunteer themselves for that, I think we'd be on board to showcase you.
But I think you're right. It does tie into like this larger how do governmental institutions view the crypto market? I think it does look, you know, tie into that issue of, you know, how much of, you know, the crypto transaction throughput is related to criminal enterprise, is related to terrorist financing, is related to, you know, money laundering, right? So, you know, people not paying their taxes basically. And so the only way they can do that is to get more and more information and just hoover up all the information they can everywhere. And so a lot of that's obviously going to come from the centralized exchanges. And I agree with you. That shouldn't be a huge surprise to people. No,
it really shouldn't be. If you're surprised, then shame on you. That about wraps it up for today's Halloween edition of Block and Order. Remember that nothing you heard here is meant to be legal advice. Please consult your own attorney if you're going to take the plunge down the rabbit hole. Special thanks, as always, to producer Abby. Without her, the show would not be possible. Have a great day, everyone, and happy Halloween.
Thank you, everyone, and please check our disclosures on our website. Thank you.